We're ready. Good, thank you very much. I'm sorry, despite the short delay due to just technical issues here, which have now been sorted out, I'm delighted that this hearing is being live streamed. The hearings to date, which have focused on production of information and documents, couldn't be public because through the Attorney General, the BVI ministers and ministries she represents reserve their rights and privileges in respect of the information and documents being discussed. I stress that the ministers and the ministries were fully entitled to rely upon such rights and privileges that they have to keep documents and information from the public, but it regrettably meant that the hearings could not be in public. As I'll explain, we're now beyond that stage, and absent exceptional circumstances, all future hearings of the Commission of Inquiry will be live streamed. As you are all aware, in January, I was appointed by the then Governor to conduct a COI to establish whether there is information that corruption, abuse of office or other serious dishonesty in relation to public officials may have taken place in recent years, and if appropriate, to make independent recommendations with a view to improving the standards of governance and the operation of the agencies of law, enforcement and justice in the British Virgin Islands. In the first stage of the inquiry, in addition to considering information which was helpfully submitted by members of the public, the COI made requests for voluntary production of information, mainly from ministers and other public officials. Just pausing for a moment, just in case there's any problem. No, we're still good to go. Many documents were provided by the government, and I'm deeply grateful to the public officials who, on top of their regular duties, have been involved in considerable amounts of work to respond to our requests. I sincerely thank them for their considerable efforts. However, the initial COI hearings held in May, to which I've already referred, confirmed that the documents produced were significantly incomplete and generally in very poor order. Often it was impossible to ascertain the story that they told. For example, I heard evidence from witnesses over several days on the BVI government contract in respect of radar barges, simply to try and understand how those contracts might have come into being. Even now, this COI does not have a full set of the relevant documents. At the hearing on the 20th of May, Sir Geoffrey Cox, Queen's Counsel, on behalf of the Attorney General, frankly and properly conceded that the BVI government's files are in, quotes, severe disarray, end quotes. And that, he said, largely explained why the documents produced to the COI had been in such very poor order. That inevitably has had a serious adverse impact on the progress of the COI. In particular, it's inevitable that the analysis of the documents and the COI hearings will be significantly more difficult and will take substantially longer. Once on the 20th of May, the Attorney General had made clear the situation with regard to the government's documents, I promptly took a number of steps to mitigate the problems that resulted. First, on the 20th of May itself, I directed that by the 31st of May, having made any further checks necessary, each minister and other public official who had responded to a letter of request from the COI for documents should swear an affidavit setting out the steps that had been taken to identify documents covered by each request and confirm that they considered that they had taken all reasonable steps to ensure that disclosure was now complete. I directed that those assurances be supported by an affidavit by the Attorney General or a senior member of her team, confirming that, in her view, reasonable steps have been taken to ensure the documents produced are complete. The Attorney General has asked for an extension to lodge those affidavits to the 7th of June, which I have granted. Those affidavits will give me some reassurance that the disclosure of documents, such as it is complete. Second, I've commissioned a specialist IT system called Relativity to manage the documents that we have. This system is widely used in public inquiries and major judge-led inquests in England and Wales, including some which receive material of a highly personal nature, such as the inquiry into the Grenfell Tower fire and the infected blood inquiry, or which engage national security, such as the undercover policing inquiry and the Germaine Baker inquiry. The system provides me with the necessary confidence that documents provided to the COI will continue to be held in a secure way, but it also has powerful search and analysis functionality, which, with the affidavits to which I've referred, will reduce the risk that poor or incomplete documents will disrupt future hearings. Third, I'd already invited those who have participant status, such as the Attorney General and elected ministers and members of the House of Assembly, and others with a particular interest in these matters, to provide me with position statements setting out their response to specific questions regarding governance and the operation of the law enforcement and justice systems. This gives an early opportunity for those with a constitutional interest in these matters to inform the work of the COI. These position statements are still being received, but subject to any compelling objection, I propose publishing them on the COI's website so that the public can better follow our work. The next step, which will begin shortly, is for the COI to issue letters requesting corporate statements from the relevant ministries, which, in respect of particular topics of interest, set out the relevant facts as they see them and explain the available documents. These, I hope and expect, will again ameliorate deficiencies in the documents and will enable more focused hearings moving forward. With those measures in place, we can resume substantive hearings, which I propose to do on Monday, the 14th of June. As I've said, unless I exceptionally grant an application that a hearing be heard in private, all hearings will be live streamed, and a link to that recording will be available on the COI website. If during the course of a hearing, counsel to the Commission or a participant or a witness considers that the evidence being given is privileged or confidential or otherwise cannot properly be given in public, then that person will make that clear to me, and the live stream will be temporarily suspended whilst that point is aired and determined. There is a 3-minute delay to the streaming, so no confidentiality will be lost. The live stream will be resumed as soon as it can. In addition to the live stream recording, once available, transcripts of the hearings will continue to be published on the COI website. I propose holding hearings from the 14th of June on the basis of a 4-day hearing week, Monday to Thursday, which will give Fridays and weekends as preparation time. Hearings will generally commence at 10 a.m. and be concluded by 4:30 in the afternoon. But as with all procedure before the COI, I will remain flexible and we are fully prepared to sit outside those times and days to ensure that our work proceeds efficiently and effectively. Key information concerning the conduct of hearings has been set out in a protocol published yesterday. Those who have already attended private hearings will be aware of some of this information, but publishing it ahead of the public hearings has the important benefit of assisting the BVI public better to follow the public hearings. I'd like now to give some more detail about the forthcoming hearings. I propose to deal with the subject matter under inquiry by topic, although that may mean that some witnesses will be called more than once. Again, this will ensure that the work of the COI proceeds in an organised and efficient manner and will give the participants a full opportunity to engage with the process. Whilst I repeat, I propose to be flexible, and other issues may arise during the course of proceedings. The proposed order in which I intend to take the topics is as follows. First, the interests held and declared by members of the House of Assembly and elected ministers. Second, questions arising from the position statements submitted by participants and others on governance and the law enforcement and justice systems. Third, the work of the Auditor General, the Internal Auditor and the Complaints Commissioner. Fourth, the composition and function of statutory boards. Fifth, the purchase and leasing of Crown land. And sixth, the system under which the BVI government enters into contracts both in general and in relation to specific contracts. Now that is an ambitious programme, but one which is, in my view, necessary to fulfil my terms of reference. I intend to allocate a specific number of days to each topic. I expect those who have the privilege of participant status and their legal representatives to make every effort to assist me and my team in maintaining the progress of the Commission of Inquiry. One way in which that can be done is if participants now make submissions on the topics I've set out, identifying any issues within those topics they consider I should investigate, and witnesses whom I should call. To have such matters raised shortly before hearings relating to a particular topic, just before they are about to commence, would be disruptive of the hearing schedule. Participants should therefore send any submissions they wish to make on those matters in writing to the COI by the 9th of June. I don't expect any difficulty with participants complying with that direction, given that it is they who have provided much of the documentation received by the COI on these topics, and at least in the case of those who have instructed the Attorney General, we've been led to believe that work has been progressing for some months. As and when the COI can give more information on each topic, for example, as to which witnesses will be called, then it will do so. I expect the first information to be sent out to the participants today or tomorrow. A rolling timetable will be available to the public on the COI website. I'd also like to say something about redaction, because this is something else which has the potential for interfering with our timetable. It is something with which the lawyers in the room will be familiar, but for the benefit of the public, redaction is a process by which certain information which cannot be made public in a document is blanked out. It means that the rest of the document can be referred to in public. There may be good reasons why a document needs to be redacted. For example, it may contain personal data or information otherwise confidential or privileged. What is redacted out is ultimately a decision for me as Commissioner, taking into account both the relevant law and all of the circumstances, including the views expressed by both participants and others, that this inquiry should be as transparent as possible. On the 5th of March, the COI published a redaction protocol. It is detailed, but put simply, it allows those who provide documents to the COI to make representations as to why information should be redacted from the documents which they've provided. However, I am concerned that the problems surrounding the disclosure received from government bodies will undermine the effectiveness of that protocol. Whilst respecting rights of privacy and confidentiality, which I will do, it is important to maintain and safeguard the hearing programme. I've therefore published an updated redaction protocol which allows the COI to invite those providing documents to identify any information they want redacted and the reasons for that request, but without rendering it necessary to rule on every redaction issue before a hearing. Such issues will only be determined as and when necessary in the light of how hearings in fact proceed. There is a balance to be struck between ensuring that sensitive information, which for legitimate reasons needs to be redacted, is not put into the public domain, and the COI being as transparent as possible, a balance which I consider the new protocol provides. I expect the legal representatives of participants to work with the COI team in a proactive way to find a pragmatic solution to any issues that might arise. I stress that none of this exercise will compromise in any way the COI's undertaking to members of the public who have made information available on a confidential basis, that material will remain confidential and the source of it will remain anonymous if that's what the giver of the information wishes. I intend to press forward with the public hearings as quickly as is consistent with my terms of reference, which require the inquiry to be not only faithful and impartial, but also full. However, irrespective of those efforts, it will be clear to all from what I've said that it is not now possible for me to deliver my report by the 19th of July, the initial date for its delivery in my instrument of appointment. Indeed, it is inconceivable that the hearings will be over by that date. I have therefore written to His Excellency the Governor, seeking an extension of that time. The Governor has been kind enough to indicate that, given the matters to which I've alluded and the sheer weight of issues which have been brought to the attention of the COI for investigation, he is in principle willing to grant such an extension, but he has asked me to report on progress of the COI by mid-July before he appoints a date by which he will require me to report. I am grateful to His Excellency. He and all of those who live in the BVI may rest assured that I will press forward with the inquiry and deliver my report with all due speed. Now, before we get on to the main business before us today, which concerns cabinet documents, just to confirm who is here for the participants. Mr. Hirey, Mr. Olympitis, Miss Knock, and Mrs. Forbes-Vanterpool, the Attorney General. Mr. Rowe, I think it is for Silk Legal, who is here remotely. Welcome, everyone. Can I just clear the decks before we begin the discussion on cabinet minutes? Mr. Rowe, if I can deal with one or two matters with you and your clients first. You, of course, represent the members of the House of Assembly who are not represented by the Attorney General, and that is those members who are not May, asking for a position statement on governance by the 31st of May. I referred to that in my opening statement. And when chased yesterday, you said that you were taking instructions from your clients. Yesterday, of course, after the date for the position statements to be lodged. Now, in the meantime, some individual members have lodged their own submissions on governance, and at least one of them I've seen looks to be very useful. But could you tell us what the position is? The members are participants. You are their legal representatives in the Commission of Inquiry. We correspond with you on a more or less daily basis. But it's very important, given the timetable that we've set, that you keep up. Could you tell us with regard to the position statement, what the position is?
Good morning, Commissioner. The legislatures are composed of both government and opposition members. And we can only forward the directives or the requests you make to us through the speaker to these members and await their response. We are just thus creatures of their instructions. I won't go into details, but there was a period where we were unable by circumstance to be active. We can only give an assurance that we will double our efforts to have the members respond in the manner which we consider quite proper and effective in conducting the inquiry. What has been sent to you has not in fact been sent to us. So it's very difficult to satisfy the requests you have made without.
Given that you applied on behalf of the members of the House of Assembly for participation status, and they applied that you represent them in the COI, that's not a very happy circumstance, is it?
Yeah, I would agree in every respect, Commissioner, but it may well be that
I can imagine what we get.
before you proceed, Commissioner, just for information, Mr. Daniel Davis is in the room with me.
Just hold on a minute, Mr. Rowe, because there's a small hitch with the live stream that we just want to correct before we proceed. Just one moment.
Okay.
Good. I'm sorry about that delay. I'm afraid when we rely upon machinery, things will go wrong from time to time. But I understand the live stream now is working. Mrs. Forbes-Vanterpool, anything to add, or are you happy to go away? And I mean, what I've proposed is that if you come back to me, or Mr. Rowe comes back to me, setting out why such a meeting would be a good idea outside the hearings, then I'll consider it.
Commissioner, good morning. If I may, I've been asked to appear before you on behalf of the Attorney General
Yes.
and the elected ministries and departments which she represents. So if I may respond to that question, sir. I am informed that the Attorney General did not initiate and was not involved in the invitation that was given to you by the Speaker of the House of Assembly. I trust that's of assistance in response to your question.
Well, certainly of assistance to determine what to do. She is one of those whom the invitation covered that I was as a person to see. So it looks as though communication has fallen down a bit or a lot. And so I think, Mr. Rowe, unless you have any further observations to make, or Mr. Davies has any more observations to make, what I'll do is I will leave it that if, and the letter was sent by the Speaker, who I know that he is your client and you're in touch with him, but if you consider that such a meeting may be a good idea, then you as his legal representative should, I think, write to me and set out the purpose of the meeting and so on, and then we can consider it in due course. Does that sound sensible, Mr. Rowe?
Totally, Commissioner.
Yeah. Yes, thank you very much. And thank you, Mr. Hyra, for confirming the Attorney General's instructions. Yes.
Before you move on to the next matter, may I just invite you to make one direction, which arises out of the responses that you've received from those who instruct Silk Legal in this COI. When the letter went out on the 17th of May, the anticipated response was that there would be one position statement from all 7 members of the House of Assembly that Silk Legal represent. And the reason for that is because there should be no conflict of interest between them. You have, as you've pointed out, received an individual position statement from one of those 7. I believe it's 2 others have asked for extensions of time to submit their own. But in addition to that, 2 members of the House of Assembly who ostensibly are represented by Silk Legal have written in the same terms to you to say that they have seen the position statement by ministers and that they are in agreement with it. Now, that we take to be a reference to the position statement that was made on behalf of the elected ministers, the persons that Mr. Hyra represents. And that was somewhat of a surprise because those 2 members are part of a group of members of the House of Assembly who asserted that they could not be represented by the Attorney General because they had no confidence in her. It seems that at least 2 now wish to associate themselves with a position statement which at the time that they wrote the letters had not reached the Commission. And so against that background, I would invite you perhaps to direct that Silk Legal by the end of today set out in the letter who precisely they still represent. Because I anticipate that if going forward we are going to have individual position statements from those that who instruct them, or
just one moment, Mr. Rowe. Just for people who can't see this, we appear to have lost the stenographer from the link.
Listen to this response.
Mr. Kasdan, can you still hear us?
Yes, I can still hear you, but I just took myself off the video. I don't know if you want me to stay on or stay off.
No. We don't need you to stay on, Mr. Kasdan.
Okay.
It's just that we wanted to make sure that you were there, but you are. Yes,
Everything
thank you.
is fine. Thank you very much.
Yeah, I'm sorry, Mr. Wright.
It's all right. I've reached the end of the point that I wanted to make. I think just some clarity as who Silk Legal still represent may be of use.
Yes, Mr. Rowe, I think that's a very good idea, subject to any observations you have, and subject to any submissions you have to make. What I'd direct is that by the end of today,
may that be tomorrow, sir.
Until tomorrow, that's fine, isn't it, Mr. Wright? Yes, because you do need to take instructions. But if you could do two things, could you write to the Commission by 4 p.m. tomorrow, confirming those members for whom you still act, and setting out the position with regard to position statements. That is, whether you are going to lodge a position statement at all on behalf of any, or whether those you represent intend to lodge position statements, and if so, by when they propose to lodge them.
Thank you. Will do.
Thank you very much, Mr. Rowe. Anything else, Mr. Wright?
Not on that matter.
Good, thank you. Mr. Hira, I'll address this to you, but this may actually be for Mrs. Forbes-Vanterpool, but you can decide. There's been some concern expressed about why the transcript of Mr. Wade Smith's evidence is not on the website. It's not been made public. And the reason is that we are waiting to hear from the Attorney General on one particular matter relating to a redaction. And that is a matter which I think you will want us to hear in private. It's only a very narrow one, but you'll want us to hear that in private. And if that's so, can we deal with that at the end of the public hearing?
Yes, sir.
Yes, thank you very much. That will then mean that that's the only thing holding it up, and Mr. Wade Smith's evidence can then be published with whatever redactions I consider appropriate. And finally, before we get on to cabinet documents, yesterday the COI team obtained the balance of the documents from the Registrar of Interests. And I think this is right. So that the COI have the documents, but the Registrar wished, I think, to take advice, understandably, on what use, if any, the COI can make of those documents. And what we did yesterday afternoon is to write to the Registrar, copy to the Attorney General, asking for a response from the Registrar on any conditions attached to the documents that we have. And we've also set that matter down for a hearing on Friday at 10 o'clock because that's something which needs to be resolved, if there are any issues, quickly in the light of the timetable. Any observations on that, Mr. Hirey?
I would need to take instructions, sir, but I think it's very clear what you've just set out.
Yes. We don't know whether there will be any issues,
yes.
But if there are, we just need to deal with them sooner rather than later. And that there may be legal issues, but there may also be pragmatic, practical issues which need to be sorted out. Thank you very much, Mr. Hirey. Now that does bring us to the main issue for today. And firstly, can I thank you, Mr. Hirey, because your name's on the bottom with Geoffrey Cox's, for the submissions made in respect of cabinet documents, if I can use that as a broad term. Can I just summarise where I think the attorney stands on this, and then you can correct me if I've got it wrong, but I hope that will help identify what issues we need to deal with today. The cabinet documents, I mean, they're actually defined in the cabinet handbook, but for these purposes, they really comprise, firstly, the agendas, cabinet agendas. Secondly, documents that go to Cabinet, normally a memorandum and supporting documents, perhaps a report. And thirdly, Cabinet minutes. And I include in that any record of what happened in Cabinet. So that's finalised minutes, draft minutes, notes before draft minutes, and now we know that some of the Cabinet meetings, which have not been, where the minutes haven't been finalised, were recorded. So there are oral recordings. And my understanding of the attorneys, well, my understanding of the Cabinet's position as relayed to us by the attorney is this, and this is what I'd just like confirmation of. Firstly, the Cabinet is willing to give the COI access to documents in these categories. Firstly, the Cabinet agendas. Secondly, the record of the Cabinet meeting, which will be minutes or drafts or notes, but not recordings. We'll come back to that. And thirdly, the Cabinet decision. That's part of the minutes, but the Cabinet decision. And the Cabinet is willing to allow us to see all of those, but for no further disclosure, no public disclosure or further disclosure, except on a case-by-case basis. Is that we'll come back to recordings, but is that the correct position with regard to other documents?
Mr. Commissioner, thank you for setting that out. I do have some submissions which I would hope and I expect would respond to the issue that you've raised, and in answering it, set out the context to that. If I may answer it in that way, sir, I'd be grateful.
Yes, not to stop you doing that, but is that the Cabinet position?
The position in summary, sir, before I come on to set out that background and context, is indeed the Cabinet is and has given all Cabinet agendas that have been sought, as well as all minutes of meetings that have been finalised, as well as all drafts of meetings, as well as of all notes of meetings, whether manuscript or electronic, as well as indeed finally the Cabinet decisions.
Yes.
So what we are seeking, sir, is your adjudication with regards to the oral recordings of Cabinet meetings, and that is something on which we consider that the public interest would need to be balanced by you, sir, and that's the point on which I've got submissions that I would like to come to.
No, and you can make those submissions if necessary, but I have to say that the submissions are well, if I might say so, very well set out in your written submissions. Can I just raise a couple of things?
I'm sorry, sir, I don't think I fully answered your question with regards to the disclosures to the public, because the position on that is that in accordance with the two-stage process, the understanding was that there would be an opportunity to address the issue of public interest immunity, for example, if there were, for instance, national security considerations that would, in particular circumstances, based on the evidence at issue, merit redaction from the public. But other than that, there is no departure, sir, from your two-stage process. There is no principal objection, as it were, that's being taken with regards to public access to even documents as sensitive as Cabinet minutes. Sir.
No, well, that's very helpful. And just to make clear, by Cabinet minutes, you mean not only the finalised minutes, but any drafts and notes, but not the recordings.
Yes, sir, I do distinguish between Cabinet minutes, which are and have a formal status under the Virgin Islands Cabinet Handbook, as distinct from drafts and notes, which don't, under paragraph 4.22 of the Cabinet Handbook, have the status as minutes. So I do distinguish between minutes and drafts and notes, but you are correct, sir, that the principle that I've set out and the two-stage process and the approach that is being taken by those that instruct me is indeed the same for the drafts and notes as well as for the minutes themselves.
That's really helpful by way of clarification. Just a couple of points. And the first is just to confirm, and I understand the two-stage process, of course, but in respect of those documents, all the documents except the recordings, you understandably wish to have an opportunity before they are made public to look at any particular documents or minutes that might be put into the public domain before they go into the public domain, to make those redactions or to make an application for bits to be redacted if you consider they're covered by whatever, a privilege or an indemnity or an obligation of confidentiality.
That is correct. So again, in accordance with the two-stage disclosure process that you've set out for your commission.
Okay, that's very helpful because, again, we'll hear from Mr. Rowett in a moment, but it seems to me that the main issue to be dealt with today is not really a legal one, because I'm not well, we'll hear from Mr. Rowett, but I'm not sure that I disagree with the legal position set out in your helpful written submission. And that is, to put it in a sentence or two, that cabinet documents, but I think particularly the cabinet discussions as recorded in, however they're recorded, are conventionally confidential as a matter of public interest. That, secondly, that it is a matter of public interest, and so that public interest may, in certain circumstances, have to be balanced against other elements of public interest. But I think you say, or certainly would say, that the public interest in confidentiality of cabinet documents is a strong one, but has to be, nevertheless, has to be balanced against other things. And almost the reverse side of the coin to that cabinet confidentiality is cabinet responsibility, because all cabinet members, once a decision is made, are bound by that decision and bound not to express any views contrary to the decision and not to reveal any views they might have expressed in cabinet with regard to the merits of the proposal that led to the decision. I mean, that puts probably inelegantly what you set out in your submissions.
Thank you, sir. I think I would put it slightly differently, if I may.
Yes.
I don't disagree. I don't think markedly, but if I may explain the position so that it's entirely clear.
Yes.
And for all, sir. So I do have submissions in respect of three matters. The first are the cabinet minutes, the final formal minutes of cabinet meetings. The second relates to the draft cabinet minutes, including the notes. And the third relates to the recordings of cabinet meetings. Now, I think it is important in terms of the background and context to the submissions that we make, sir, to keep in mind that the cabinet system is a new form of government introduced into this territory in the 2007 Constitution.
I'm sorry, but in relation to these submissions, I'm not sure they're contentious.
But sir, this is relevant also to the recordings. And it is important, I believe, and also for the public to be aware and to have a transparent position in terms of, if I may, sir.
Yeah, no, and the way you propose to do it may be the best way of doing it, or your preferred way of doing it. What I'm particularly interested in is the difference in principle between the recordings and draft minutes.
And I certainly intend to address you on that, sir.
Yes, thank you.
Thank you. So Article 47(3) of the Constitution provides that Cabinet has responsibility for the formulation and the implementation of policy on, and I quote, every aspect of government, end quote, save those for which the governor has special responsibility. You have heard, Commissioner, from the Cabinet Secretary on the Cabinet Handbook, which is the authoritative instrument governing Cabinet and its proceedings and strictures in this territory. I would like to take you, sir, to the Cabinet Handbook and two important principles that apply in this territory. And it is, Commissioner, in bundle C1 that you have before you. This is the Cabinet Handbook of the Virgin Islands. It's on page 11. It's paragraph 2.1 at the top of the page. And it provides, and I quote, collective responsibility is at the core of the cabinet system of government, end quote. What that means is that cabinet speaks as one executive authority, one voice. This constitutional convention of collective responsibility was addressed by Mrs. Justice Ellis in the case of Claude Skelton Klein versus the Cabinet Office of the Virgin Islands. That's a recent judgment in this jurisdiction of the 23rd of May, 2019 in the BVI High Court of Justice. The reference is BVI HCV 2016/0063, and that can be found, sir, at bundle C, tab 2 before you. And in that ruling at paragraph 120, Mrs. Justice Ellis held that cabinet collective responsibility, and I quote, prescribes that while ministers may express their views privately, once a decision has been made by the cabinet, it is binding on all members of cabinet, and they must publicly show a unified position. End quote.
With respect to Mrs. Justice Ellis, and it is with great respect, but that is trite law, isn't it?
It is important law, sir. It is trite because it is important, and it is generally
well established.
It is well established, sir.
Yes.
It is well established, and in this jurisdiction as well, sir. Yes, I would agree. And this leads on, sir, to the second principle, which flows from collective responsibility, and that is the one to which you alluded with relation to it, namely cabinet confidentiality. Now, that obligation of publicly showing a unified position is what necessitates cabinet confidentiality of discussions in cabinet, which Mrs. Justice Ellis eloquently described as, and I quote, a natural correlative of collective responsibility, end quote. And that, I believe, sir, is something similar to what you were saying earlier. For without cabinet confidentiality, how could cabinet ministers speak freely in cabinet while ensuring that collective responsibility on which cabinet system government is based is upheld?
But again, all of this is trite law, isn't it?
Yes, sir. It is in the sense of it being generally accepted, but nevertheless important, I would submit, sir, to the submissions that I'm making.
Both the confidentiality and the responsibility, collective responsibility, confidentiality in cabinet dealings, well established, because it's in the public interest.
That is correct, sir. It is in the public interest. Now, there are points which I don't believe are necessarily, as you would put it, trite law, in the sense that there are differences between the principle of cabinet confidentiality, at least in the temporal aspect in this jurisdiction, as compared with in England and Wales. And if I may, sir, I would like to come on to address also those differences.
But there are differences here because it goes on forever. And it's arguable that in other jurisdictions it may not go on forever. But that's not relevant here because we're not thinking of forever. We're thinking about the last period of time.
And that period of time, sir, is less than 1 year in the context of every single recording
but all that
we are discussing.
But all that means is, with respect, is that the public interest in confidentiality may be stronger than if we were concerned with matters that happened 10 or 20 years ago.
And I agree, sir. I think it does show that the public interest in confidentiality is higher in this jurisdiction, in that respect, certainly, than in England and Wales.
Yes.
And if I may come back to my submissions, I'd like to go through illustrations of that in the context of the Cabinet Handbook that applies here to this issue.
But nobody's saying that all of this is set out in the Cabinet Handbook. And certainly speaking for myself and not for Mr. Rowett, who will make submissions in a moment, it's all uncontentious.
That may well be to you, sir, but it may not necessarily be clear to the public. And since we've had an opportunity to make submissions to you today, I hope I will not take up too much time if I may be allowed to complete those submissions.
Okay, thank you.
Thank you, sir. I'd like to refer next to paragraph 2.10 of the Cabinet Handbook, which is at bundle C1 again. And here it provides, and I quote, "The concept of collective responsibility and strict confidentiality goes hand in hand. Cabinet business is therefore conducted in strict confidence and is only broken with the permission of Cabinet," end quote. And now I come on to the time dimension, which we were just discussing, because paragraph 11 of the Cabinet Handbook is entitled, as you anticipated, sir, "Confidentiality maintained in the future." And it provides, and again I quote, "Cabinet confidentiality on a particular issue or during a discussion must be maintained in the future," end quote. And that is reinforced by paragraph 2.13 of the Cabinet Handbook, which provides, and again I quote, "Cabinet confidentiality and collective responsibility are permanent and are never to be broken, with or without the permission of individual ministers." Now, despite this very strict framework, there can be a limit in time after which Cabinet documents may be disclosed. In Attorney General versus Jonathan Cape, the Crossman Diaries case, Lord Widgery, Chief Justice, noted in England and Wales that 10 years had passed following the relevant Cabinet meetings. And he contrasted that 10-year time period with a 30-year period, which he rightly said did not apply in England regarding the confidentiality of Cabinet discussions. And that is at Bundle C, tab 4, page 126, page 771E within the judgment. Yet, sir, the position is different in this territory. Indeed, the Virgin Islands Cabinet Handbook explicitly provides at paragraph 7.32 that, and I quote, "Cabinet discussions are not open to the public until after 30 years, end quote. So the 30-year time period that Lord Widgery rightly said didn't apply in England does explicitly apply in this territory. Now, to put that in context, sir, all of the recorded Cabinet meetings that we are discussing took place within the last year. In other words, less than 1 year ago. And we submit, sir, that that is a matter that does raise an issue in the public interest, because not least as Lord Widgery observed himself in the Crossman Diaries case, and I quote, "It is unnecessary to elaborate the evils which might flow if at the close of a Cabinet meeting, a minister proceeded to give the press an analysis of the voting," end quote. Now that must apply with greater force to the disclosure of the Cabinet discussions that preceded the voting. Now that is the background. The first issue that I would like to address, sir, is the Cabinet minutes themselves. The principles that I have addressed, of course, apply to Cabinet minutes. Notwithstanding, sir, these important principles in this territory, Cabinet has decided to give your commission all of the Cabinet minutes sought. Every single one of them sought without exception. And I've been informed that all have been sent to the COI.
In coming to that decision, Mr. Hyru, and obviously I'm grateful for it, the Cabinet presumably took into account the public interest in the inquiry, seeing the documents, as well as the public interest in confidentiality of Cabinet proceedings.
So Cabinet has adopted a policy of transparency and of cooperation with your inquiry. And this is I would submit, very clear reflection and evidence of that, notwithstanding the important and sensitive principles with regards to Cabinet confidentiality and Cabinet collective responsibility in this territory. So
they've taken into account the public interest in the COI seeing these documents.
They've taken into account their policy of being transparent and constructive with your commission, sir. Yes.
Yes, thank you.
The second point is the draft Cabinet minutes or notes that were taken of meetings. Now here, sir, I think one can observe that there are notes that have not been finalized and turned into Cabinet minutes, notes of meetings, due to the very high volume of Cabinet meetings that took place in 2020 in the context of the COVID-19 pandemic and the government's response to it. And as we can imagine, this territory's success in managing COVID-19 is not fortuitous. Whereas in an ordinary year, there might be 40-odd meetings of Cabinet, in 2020, there were not less than 94 meetings, of which 51 were special meetings to discuss the COVID-19 crisis and the government's response to it. The result of that was that not all minutes could be finalized in the ordinary, timely way.
How many were finalized, Mr. Hyru?
So I'd need to come back to you with the exact statistic, but I believe it is set out in a table, which is at the back of the application.
I think it's 21, I think, out of the 94 have been finalized.
Well, I'm sure I will be told if that figure is incorrect, sir.
And of the requests made by the Commission, which I think there are 25, 5 sets of cabinet minutes have been finalised. The others are mainly in note form, 1 or 2 in draft, but mainly in note form.
Again, sir, I will revert back to you if there is reason to doubt the figures that you have given. The result of that, sir, was that not, as you note, all minutes could not be finalised in the ordinary timely way, given this deluge of meetings, some of which lasted more than 1 day. Notes taken of those meetings are not operative as minutes, a point, as I made earlier, that is set out in paragraph 4.22 of the Cabinet Handbook. And even in England and Wales, where there is a Freedom of Information Act, which does not exist in this territory, it has been held that disclosure of draft minutes and notes is more problematic and damaging to the public interest than the finalised minutes themselves. Now, that is not least because they may contain errors of both accuracy and attribution. And I would refer you, sir, in this regard to Cabinet Office versus the Information Commissioner. It's a decision of the Information Tribunal of England and Wales, and that is at bundle C tab 3 before you. And in that case, the Information Tribunal refused to order disclosure of draft minutes of cabinet meetings regarding the decision to go to war in Iraq.
Just can you help me with this? Paragraph 4.22 of the handbook, which I think it explains quite a lot. The outcomes of cabinet deliberations, it says, are recorded as cabinet minutes by the cabinet secretary, assisted by the cabinet recording secretary. Cabinet minutes are not operative until they are confirmed by cabinet and signed by the cabinet secretary and chairman of the cabinet. So what that, looking further on, what that envisages is that cabinet minutes are prepared, presented to the next cabinet meeting and signed off. And it's only then that the decisions become operative.
That's correct, sir.
Now, in circumstances in which very few of the cabinet minutes have been finalised over a period of about a year, where does that leave the decisions?
So my understanding is, but I may need to revert to you on this if it proves not to be correct, but my understanding of this is for that period, essentially June to December of 2020, decisions were nevertheless taken, and there can be extracts of the decision which can be circulated, but the minutes themselves, which can also record discussions, at least as a matter of practice, the minutes have come to record the discussions and deliberations that preceded the decisions. It is those minutes that reflect also the discussions and deliberations that have not been finalized as compared with the decisions themselves. And I'm told that that is the case, sir.
Well, that's very helpful. And where is that in the handbook? Where's that procedure in the handbook? I'm sorry, it's not intended to be a sort of test.
Well, let me come back to you on that, and if I may, sir.
Yeah, so where is the authority for cabinet decisions which are not the subject of finalised minutes?
I have your questions.
Yes, thank you very much.
Thank you. So if I may revert to the case of Cabinet Office versus Information Commissioner, as I was saying, that's a decision of the Information Tribunal of England and Wales. And in that case, the Information Tribunal refused to order disclosure of draft minutes of cabinet in England regarding the decision to go to war in Iraq.
In that case, were the finalised cabinet minutes? In that case, were the finalised cabinet minutes?
Were there final? Yes, there were finalised cabinet minutes in that case. Yes, sir. The point that I am addressing here, though, having addressed finalised cabinet minutes, is the drafts and the notes, and that's the relevant point for the purposes of my submission, which is that despite the significant public interest in obtaining those notes and drafts under the Freedom of Information Act, again, as I say, there is no such Freedom of Information Act in this territory, the Information Tribunal nevertheless refused to disclose the drafts and notes, and they held as follows, quote, disclosure would be likely to have a greater impact on debates within Cabinet and the manner in which a record of them was maintained than in the case of the minutes themselves, end quote. They went on to say that, and I quote, they believe it could have a further damaging effect in that the manner in which an individual takes contemporaneous notes is likely to be idiosyncratic and could well give a false impression as to the weight and importance that should be attributed to a particular part of the debate or the tone in which the points of discussion were expressed, end quote. And what this shows is that there is a greater sensitivity and deference towards non-disclosure in the context of drafts and notes than the finalized minutes themselves, for reasons that have been given, including errors possibly of attribution and of accuracy. And yet, nonetheless, consistent with the government's policy of transparency and cooperation with your commission, Cabinet has again decided that also all drafts and notes are to be disclosed to you. And once again, sir, I'm informed that this too has been done.
No, and we're very grateful. But again, the public interest in confidentiality in these drafts has to be balanced against the public interest in the Commission of Inquiry seeing them.
Absolutely, sir. And they have been disclosed in their entirety.
No, and I'm very grateful, because otherwise I would have had to look at them and decide where the public interest lay. So I'm very grateful.
Thank you, sir. It does bring me on to the recordings of Cabinet meetings, which is a matter that you had asked about as well. And of course, ordinarily recordings of meetings of Cabinet would not be made. As we know, not here, not in England and Wales. And the reason that they were made on an exceptional basis is that the volume of meetings in 2020 necessitated it, so that the minutes could be prepared thereafter. Now, former Governor Jaspert and the ministers could have had no idea at the time that every word they spoke in Cabinet could be publicly disclosed after the hearings had been recorded. And to return to England, in the Court of Appeal case of D versus L, which is at Bundle C, tab 10 in your folder, Lord Justice Waller made observations which amply support the proposition that recordings should be approached with particular care and sensitivity.
In what context was that?
Well, it was in a very different context, sir, but it does, I believe, nevertheless make the point about sensitivity with regards to recordings. Now, sir, I'd like to place these submissions in the context of this territory. The Cabinet of this territory did not authorize the Commission of Inquiry. They were not consulted on it, nor even were they given meaningful notice of it before it was launched by the former governor. Now, that is plainly different, sir, to what happens in the United Kingdom when a Commission of Inquiry is initiated, where such a commission is approved by Cabinet. The law used to launch this commission is more than 100 years older than the establishment of Cabinet government in this territory. That 1880 Act permits any governor to issue a commission for this territory whenever he thinks it advisable. If you can reach in from the United Kingdom whenever a governor so chooses and obtain the recordings of the Cabinet of this territory, why would elected members of Cabinet ever speak freely and openly in Cabinet again? Such a potentially chilling effect on what is said in Cabinet is, in our respectful submissions, a matter of public importance in this territory. Yet even here, a constructive approach has been taken by the elected government to your commission. The government has brought to your attention the existence of the recordings. Therefore, we seek a written ruling from you, sir, on 2 points. The first, do you wish to direct the production of recordings of the governor and Cabinet under stage 1 of your 2-stage process? And number 2, if so, we would respectfully invite your adjudication to weigh and balance whether the public interest of producing such recordings to the COI outweighs the important principles of Cabinet confidentiality and collective responsibility in this territory to which I have referred. Thank you, sir.
Thank you. I think, Mr. Hyrie, with respect, we go back to where we started, and that is, I still don't understand the difference in principle between recordings, which will be accurate, and draft minutes and notes, which you say will contain inaccuracies. What is the difference in principle between a recording of discussions in Cabinet and notes made in Cabinet of those discussions? What's the difference in principle?
The notes are a prelude to the formalization of the cabinet minutes themselves. Cabinet minutes do not, as a matter of practice in this territory or indeed elsewhere, reflect every word that is said in cabinet. They are designed to summarize the essence of a particular position, the gist, if you might like. They are not a verbatim account, and the notes are no more a verbatim account of what is said. On the other hand, a recording is a verbatim account.
But with respect, therefore, the recording has benefits. So, for example, if the notes record the position taken by a particular ministry in cabinet, you accept that those notes may be wrong. The recording won't be wrong. It's not the only element of public interest, but the recordings have some benefit.
Well, I don't say that may not be a factor you would wish to consider in the context of the weighing, but I do say, that there is, in answer to your question, if I may, that there is a difference, not least because things may be said that are not for the purposes of the minutes themselves in the context of a private conversation. And that is the nature of a recording. There are real issues, not just for former Governor Jasper, but of course in the context of anyone being recorded, where they are then going to be taken in a verbatim transcript. And so that is what we would say, sir, that it does raise an issue that is to be factored into your weighing of the public interest.
I'm sorry, but I accept that. There's no doubt about that. But if it's to be weighed in the public interest, which I have to balance, are you saying that there's no difference in principle between the recordings and the draft minutes?
No, I'm not saying that. I'm saying there is a difference in principle.
What's the difference in principle? You say that I have to weigh up in a public interest balance what I hear on a recording and other strands of the public interest. How can I weigh what's on the recording in the public interest without listening to it?
Well, so that goes to your second stage of the process, and
we're only on the first stage.
I know we are, sir.
So,
but your question goes to the content. What we are saying is that in principle, there is a difference between a recording and a handwritten note of it. And we would submit that most people would recognize that. It's a point that was made by Lord Justice Waller in his case, where he said, and I quote, "The recorded details of the very words of a private conversation can make more impact and cause greater embarrassment and distress than a mere account of the conversation in question," end quote. It's from a different context, sir, but I believe that most people would understand that having their every recorded word transcribed and then disclosed is a different matter from a formal summary of the essence of cabinet deliberation and decision-making.
So how do you expect me to weigh in the public interest the confidentiality due to the recordings, which you say is very strong? How can I weigh that without listening to the recording?
Well, sir, we've made before you our submissions on the point. You have our authorities in support of it.
How do I do it? How in practice do I do it? How can I take into account something that you say I can't listen to?
Well, sir, I don't say you can't listen to it. What we say is that it's a matter of adjudication for you in the first instance to weigh up the public interest as a matter of principle. Even here, sir, as I say, the government is taking a constructive approach. We are not simply saying you cannot have it. We are saying it does merit adjudication. It's an important point of principle, sir, for the reasons I've given.
But it's not an adjudication on principle that I can't listen to any recordings. You say that in an appropriate case, the cases may be few, I can listen. In fact, I'm bound to listen to the recording to weigh it in the public interest.
No, that's not the position we're taking, sir. The position we're taking is that at this first stage, we would invite you to make an adjudication on principle with regards to the weighing of the public interest for recordings qua recordings. With the second stage, as you set out to be addressed in the context, if you so find the answer to the first stage to be yes, of any specific issues that were discussed.
But can't I only consider the public interest in relation to particular circumstances? I can't consider the public interest in a vacuum.
Well, we would invite you, sir, to consider the submissions that we've made to give information that we say is pertinent to the determination in principle of the adjudication with regards to the recordings. And that is, as a preliminary matter, the submissions that we have made before you, sir. It's for you, of course, to determine whether you are persuaded by that there is a real public interest that needs to be weighed in the context of the submissions we've made, or if there is no weighing that you would wish to do at this stage in principle based on the submissions and authorities you have before you, sir.
Thank you. Mr. Rawat.
So may I start just with a point that Mr. Hari relies upon, which is the fact that this commission of inquiry was not established by cabinet. He contrasts this with the position in the United Kingdom. With great respect to him, I do not accept that in the United Kingdom an inquiry would be ordered by cabinet. That is wrong. The Inquiries Act of 2005, which is now the primary act under which inquiries are set up in England and Wales, and there are similar statutes in Scotland and Northern Ireland, is that it is a minister that establishes an inquiry. Prior to that, the enactment of that act, the leading statute was the Tribunals of Inquiries Act 1921, which required a public inquiry to only be set up following a resolution of both Houses of Parliament. And there were subsidiary pieces of legislation which allowed ministers again to establish, for example, the Department of Health could establish an inquiry. To my knowledge, and no doubt Mr. Hari will correct me if I'm wrong, but I'm not aware of cabinet having a statutory power to establish an inquiry. In any event, even if I'm wrong, the point is a bad one for this reason, because it ignores the fact that yours is an independent inquiry. You may have been established by the governor, but you are independent of the governor. And it also seems to be a bad point to say that had you been established by the cabinet, then the issue which you are being asked to adjudicate upon would not have arisen. You are either provided with relevant material or you are not. The issue at the heart of today is about disclosure of cabinet material, if I may call it that, and you have already broken it down into different categories. There are the cabinet papers that are put before cabinet. Secondly, there are finalized minutes, which are the product of the work of the cabinet secretary. Then we have draft minutes and notes, and also then, if you like, the record of decisions, which as Sandra Ward has explained to you when she gave evidence in private hearing on the 4th of May, are recorded either, and she says this in her affidavit, which Mr. Hari relies upon, either regular extracts or expedited extracts. Now, as I understand the position, all of that is material that, in response to requests, the position of elected ministers is, and of the Attorney General, is that you are entitled to see that, at least the first stage, and you're entitled to see it unredacted. That is, without any information on it blanked out. The reason, and so perhaps what I would add is that the saga, and it has been a saga, of the COI obtaining cabinet material has been a lengthy one. We have been asking for disclosure of cabinet material for months. They are only now coming through to us in a form that can be used. We only learnt, or you only learnt, so of the existence of draft minutes on the 4th of May 2021 when Miss Ward was giving evidence. She did not reveal then that these recordings existed. The COI was only informed of that on Monday, May the 24th. Now, that's some background for it, but it seems to me the first point I would like to make is if Cabinet has taken a policy decision, and Mr. Hari explains that it is based on the need for transparency and to cooperate with the COI. If they have taken a policy decision to disclose all of that material to you, that in itself undermines the argument that you are not entitled to see or to receive the electronic recordings, because they are simply a different form in which the same information which those who instruct Mr. Hari agree is relevant is recorded. If I just briefly turn just to the law, I accept that the Convention of Joint Cabinet Responsibility is important to the effectiveness of the system of government that operates within the Virgin Islands. I accept that that convention sits alongside the Convention of Cabinet Confidentiality, and that precludes, therefore, for example, ministers discussing cabinet decisions in public. So to give a more precise example, were a minister to give a lengthy statement at a press conference and then start giving details to the different views of those attending a cabinet meeting, or to comment on the actions of another attendee at that cabinet meeting, that would breach the convention. Now, that's relevant in two ways. I would say that at a later stage in the process, it may be relevant to your consideration of where the interest lies if there have been such comments made in the press. And it also, confidentiality in this jurisdiction does not appear to be absolute, because there are post-meeting statements issued which set out what was considered at a cabinet meeting, and decisions are made available and appear on the website of the Virgin Islands government. That reiterates, I say, the third principle that really applies, and in my submission, it's the principle that is really engaged here. And that is that neither convention operates as a complete bar when considering what material can be given to a court or a tribunal, or indeed a commission of inquiry. It is ultimately for the commission, in this case, to adjudicate whether disclosure should be made to it, and then what use can be made of that disclosure. And that is the decision you're being asked to make. You are being asked to decide where the balance of public interest falls. Now, Mr. Hari has referred, Mr. Hari, I apologize, has referred to the two-stage process by which the COI receives documents. The first stage is to obtain and receive all potentially relevant material. And the comfort that is given to those who provide that material at that first stage is that it comes with the safeguard that it is only seen by you, sir, and your team. The second stage, which we are not yet at, concerns, put simply, what use can be made of the material. And that is whether the material can be deployed, for example, in a public hearing. It concerns whether it can be used in your report. And that is at which stage, as you have indicated, you will welcome and you will afford an opportunity to those who have provided that document to ask that it be redacted, or that certain information contained in it not be referred to in, for example, a public hearing. We are at the first stage, and a better way of describing the first stage is receipt of relevant material. And so if one bears that in mind and considers the essence of Mr. Hari's submission, which is that you should not be provided, even alone, and notwithstanding the safeguard that it comes to you alone, with electronic recordings of cabinet meetings. The first is, the point I would make is that the relevance threshold, which should be seen as a low one, potential relevance, has already been crossed. And that is because material which refers to the same subject matter has already and will continue to be disclosed to you. And so to distinguish electronic recordings from a note is to make an artificial separation. The second point I would make is that caution has been expressed both in correspondence to you and in the written submissions that you've received, that the draft minutes may contain inaccuracies. And this is a point that you have canvassed with my learned friend. One can imagine easily a situation where at a hearing of the COI, the AG having agreed or accepted that a draft minute can be put to a witness, that the witness says, well, that's not an accurate record of what I said. If you then were to call the Cabinet Secretary and she were to assert, either in oral evidence or on a in an affidavit, that in fact it was accurate, then how are you to adjudicate on that point without going back to what is the best evidence available to you, which is a recording? I pick up at this point a submission made by Mr. Hirey, which is this, that the recording may contain ancillary material. There may be private conversations which are not relevant. Well, firstly, it's difficult to really understand the circumstances in which a private conversation would arise in the context of a cabinet meeting. Secondly, those engaged in the private conversation would, I anticipate, have been aware that it was being recorded, and to some extent been aware, therefore, that it would have been heard by others. And I would point out that, for example, in order to provide to obtain transcripts of the recording, Ms. Ward, the Cabinet Secretary, has engaged the services of a stenographer, a court reporter. But it also ignores the fundamental point that you, sir, as Commissioner of the COI, have significant judicial experience, and judges are trained to determine or to identify the difference between relevant material and irrelevant.
I'm sorry, this is a court reporter. I've lost you.
Sorry.
Thank you.
So I could ask Mr. Kessler at which point he lost me.
Yes. Thank you, Mr. Wright.
Shall I just carry on?
Yes,
sir?
yes. Thank you.
I think that the final point, and it returns to, I think the submission that you're being asked to make is, without sight of the electronic recordings, you should at this point make an assessment of where the public interest lies. What if you were to undertake that exercise, and these are factors that would come into play whether or not the recordings were available to you, but you have on one side the argument that the need to, or the public interest in maintaining the conventions of joint cabinet responsibility and cabinet confidentiality in particular, particularly where it relates to matters which are recent in history. That's one public interest, and which it is submitted to you, it should be preferred. That has to be balanced against, in my submission, firstly, the subject matter of this inquiry. You are being asked to investigate whether there is information that tends to show corruption, abuse of office, or other serious dishonesty on the part of public officials elected or appointed. That is not just a wide term of reference, but it is also one that is enormously significant. You are also being asked to look at the systems of governance, law enforcement, and justice in this jurisdiction, and to make recommendations. And you have heard submissions already, both from those instructed on behalf of the AG and on behalf of 7 members of the House of Assembly, about the ramifications of that. And you are in the process of receiving position statements on them. The second factor that goes on the other side of the balance, to Mr. Hirey's point, is the need to promote the transparency of the COI's work and proceedings, which is something that, as I understand it, both the Attorney General and those she acts for are very keen to promote and sustain. And as I've said, I've made the point that having already taken a decision to disclose the same information in a different form to you, that's a point that's relevant to that factor. Another factor I would point to is the need for the public to understand how government decisions are taken in the context of the COI, which, as I've said, is fundamentally concerned with good governance and has the power to make recommendations. Those submissions from me boil down to this. In my submission, you cannot properly assess the public interest and determine where the balance lies without some understanding of the content of these recordings. And given the protective factors that exist, given that it cannot be said that these recordings are not relevant, the first stage is satisfied. And in principle, these should be disclosed to you. The way forward, I would suggest, is that all those involved here, both the COI and those instructed by the Attorney General, should take a pragmatic and proportionate approach to this. What is most important at this stage, in order to preserve the hearing schedule, particularly, is for the COI and for you, sir, to be assured that you have seen the papers that went before Cabinet and you have seen the decisions that follow from that. Once you are satisfied of that, it is easier to then assess the extent to which Cabinet minutes that might record the deliberations or draft minutes or electronic recordings need to be used. And so what the pragmatic approach I would put to you is that whilst I maintain that the principle is that you are entitled to this material, the Attorney General should agree to ensure that the recordings are preserved, and the COI will then ask for inspection of any recordings on a case-by-case basis. So unless there's any other matters on which I can assist, I have nothing to say at this point in time.
No, thank you very much. Mr. Hyrie.
Thank you, sir. Yes, I have responses on 4 points in particular. The first is that Mr. Rawat took a point with regards to the authorization of commissions of inquiry. The point being that in the United Kingdom, it is a Minister of Cabinet of the United Kingdom Cabinet who can authorize a commission of inquiry. In the Grenfell inquiry and in the blood infection inquiry, as well as with regards to the COVID inquiry, it was no less than the Prime Minister. And of course, he sits in the Cabinet. That is a very different position than the situation in this jurisdiction, where no Minister of Cabinet has been involved in the authorization of this commission of inquiry.
But how does that affect the public interest? The public interest that I'm considering here?
I will explain, sir. Because the public interest that you are considering here must necessarily include the chilling effect that disclosure of recordings of Cabinet discussions can have on open and frank discussion within this Cabinet in circumstances where a commission of inquiry can be called at any time by another body, the unelected part of the government, thereby acquiring them in a way that would not be the case for the United Kingdom. That is why in this territory and in this circumstance, it is a relevant consideration with regards, we would respectfully submit to your weighing of the public interest in this territory.
What, that they may be put to an improper use?
No, sir, not that they may be put to an improper use, but that the principle of open and frank discussion in Cabinet may not happen in the same way if Cabinet members were to perceive that a governor at any time, an unelected element in terms of the governance of this territory, could get the discussions that are ordinarily subject to strictures of confidentiality and collective responsibility. In other words, they may not have open and candid discussions in Cabinet anymore in the same way as the principle requires in order to have meetings of Cabinet properly minuted, properly recorded, reflecting an open deliberation and discussion, because of the perception that at any time a governor who considers it advisable may authorize a commission of inquiry to access those minutes. That simply wouldn't happen in the United Kingdom.
But the governor won't get these minutes. I'll get them.
Well, yes, although you report to the governor, but I think the point that's made in that.
No. I mean, with respect, that's what do you mean I report to the governor? My report has to go to the governor.
Well, there are two separate points, sir. The first is that in the United Kingdom, the report with regards to a commission goes to the minister. In this case, it goes not to a minister of this territory. Your report goes to the governor. That is one point. There is a separate point with regards to who has access to these documents, and in particular, I should say, recordings when they are given to you. The point that was made in that regard is that they only go to you. Of course, we know that's not the case. The FCDO is a data controller, a joint data controller of all information that is given to your Commission of Inquiry team. So it is not, I would respectfully submit the case, that these recordings would only go to you. They would also go to the FCDO. They would also go to the Commission of Inquiry team. So,
I mean, with respect, this is complete nonsense.
Is that not the case, sir, that the FCDO is a joint data controller? I may have misunderstood then.
FCDO is not a joint data controller, but even that is what Mr. Hirey makes a serious allegation.
Yes.
I'm sorry, that is a really serious allegation.
I'm sorry, I may have misunderstood you.
No,
You say that they're not
can
a
I
joint
just
data
explain
controller?
my point, please? It's not about joint data controller. What your allegation is about whether the Commission of Inquiry is routinely sharing its information with the FCDO.
No, sir.
No, I'm sorry, that is the implication you make, Mr. Hirey, and I must put it on the record that it is one that I reject.
May I ask you please to
No,
clarify,
I'm
sir?
sorry.
Is the FCDO a joint data
I'm
controller
not
or
going to argue with you on this point, Mr.
Can you
Hirey.
answer
What
the
I
question?
want to do.
No, because Mr. Rawat is not in charge.
Yes,
I
sir,
am.
of course.
But he makes a good point, and it goes even beyond that, which is a good enough point. But it also goes to the independence of the inquiry.
Sir, I'm not in any way impugning. Please let me clarify your independence. So the independence of your inquiry.
Why did you mention the FCDO?
Well, sir, because the point that was made, I understood it by Mr. Rawat, is that as a factual matter, it would be only you that would have access to the recordings that were submitted to you. And the point that was made, and I think it's a matter of fact, but I may be corrected, is that in actual fact, it would go also to your Commission of Inquiry team, and it would go also to the Joint Data Controller. If I'm wrong on that, I stand to be corrected, and I would invite correction on it. I believe it's on the Commission of Inquiry website, which is that it says, for the purposes of data protection legislation, the Commission and the FCDO are joint controllers of the data collected. If that's wrong, I would be glad to be corrected.
It is wrong. That's out of date. It is wrong. That's been corrected.
Well, thank you, sir, for bringing that to our attention. I was not aware of the correction.
But the point is more. I'm sorry, sir. I'll ask in due course to make a submission on this.
As I've said, it seems to be more fundamental than that. It suggests that the FCDO have access to the documents which only I have access to and my team have access to. That is simply wrong.
Thank you, sir.
And even the suggestion is, firstly, the suggestion shouldn't have been made, and it's deeply unhelpful to an independent Commission of Inquiry when there's a suggestion that it is not independent.
Sir, I did not mean to suggest for a moment that you were not, and your inquiry was not independent, sir.
Well, the suggestion that the FCDO can look at any documents they want to is clearly a suggestion that we're not independent.
So there would seem to be a correction which has been made with regards to what's on the website in this respect, and I'm grateful for that correction. And I certainly did not mean to suggest anything with regards to your independence.
Good.
And I apologize if any such imputation was perceived. I certainly did not intend that to be the case. I was merely trying to address what I understood to be the factual position. I've been corrected on it. I understand that the FCDO is not a joint data control.
Well, that point's a bad one. Is there anything else, Mr. Hirey?
Yes, sir. There were two other points that were made that I'd like to respond to. The first is that the point was taken by Mr. Rawat that it is not absolute in terms of the principle of confidentiality, and I would accept that, of course. And the term that is, as a matter of trite law, used in this context is that it is not a rigid dogma. It's certainly not a rigid dogma, confidentiality. That's not what was submitted. What was submitted is that there is an issue of public importance, And then in the weighing of that public importance, there are very real and serious issues to be considered and weighed by you, sir, in your discretion.
In assessing that, because you're asking me under no circumstances to listen to any of the recordings, whatever the circumstances. So just to take Mr. Rawat's example, which frankly is at the modest end of examples, if a draft minute is used and presented to a witness, a cabinet minister, in the course of a hearing, and he says that cabinet minute is wrong, that draft minute is wrong, you accept that it may be wrong. You accept that.
I do,
because
sir.
it may be inaccurate.
I do, sir.
Are you saying that it would not be in the public interest to look at that particular part of the recording and determine whether he said it or not?
I can see very well, so that may be a relevant factor in your determination.
So that means that I can't strike out this whole thing as a class. I have to look at each case on its individual merits, which in terms of public interest, in my experience, is always the case.
That is a matter for your determination, sir.
But you've accepted.
To get for you to get an external microphone that will capture your words better, because it sounds warbly when you speak, because it's catching the ambience of the room.
Mr. Rowe, Mr. Casson, can you hear me?
I can hear you.
Yes, I can hear you.
Oh, lovely, thank you. Apologies for the delay. It was a technical glitch we've experienced with the live stream. So we're going to come back into session shortly, in the next few minutes, I hope. But we won't be live streamed, but we will, of course, record the rest of the session, and then the full recording will go on to the website or the YouTube site later on this afternoon. So if you can bear with me for another few minutes, we'll be in contact very shortly.
That's fine.
Okay, okay, I appreciate it.
Thank you.
Thank you. Yes.
Thanks for your understanding.